PGALs are almost always appointed for the court's convenience, not the child's benefit or for the benefit of seeking the truth. In many child custody disputes, the phrase appointing a PGAL, or private guardian ad litem, comes up before anyone explains what it really means. The private guardian ad litem in Utah custody cases is an attorney appointed by the court to represent what the PGAL believes to be the child's best interests. The PGAL is not the child's therapist, not a custody evaluator, and not the judge. The PGAL is not an expert witness or a fact witness. The PGAL does not decide custody or parent time, and the PGAL does not simply repeat whatever the child says he or she wants. PGALs are usually discussed in noble language. They are appointed for the child. They give the child a voice. They supposedly help the court see past the fog of parental conflict. Sometimes that may be true, but anyone who works in child custody disputes long enough in Utah knows another truth. Courts often value PGALs for reasons that have little to do with whether the PGAL actually benefits the child or helps find the truth. Courts value PGALs for case management, liability diffusion, settlement pressure, institutional convenience, and giving the judge an intermediary when the judge does not want to hear directly from the child. None of those things is inherently evil. Courts have crowded dockets. Judges have limited time. Child custody disputes are messy. But institutional convenience is not the same thing as serving a child's best interests. The biggest problem is that the PGAL can become a substitute for evidence. A PGAL is a lawyer. Yet in practice, PGALs are often treated as investigators, quasi-evaluators, child interviewers, custody commentators, and recommendation makers. If an expert gives an opinion, the expert must be qualified. The methods can be tested, and the opinion can be challenged. If a regular fact witness testifies, the witness is under oath and subject to questioning. A PGAL often fits neither category, or if it does, not very cleanly. Hearsay becomes information gathered by the PGAL. Credibility judgments become observations. Unsupported impressions become concerns. Recommendations built on untested assumptions become best interest advocacy. You see a pattern here? That is evidentiary laundering. It's not child protection. It is not due process. A child's voice is not a procedural inconvenience. It is evidence, not perfect evidence, not controlling evidence, but often some of the best evidence of the child's experience, perceptions, maturity, fears, preferences, and relationships. If a judge can be trusted to decide what is in the child's best interest, the judge can be trusted to speak with the child in a controlled judicial setting with safeguards and on the record. In law, invisibility is not a virtue. It's a danger.